Distinguished representatives, please regain your seats. As we indicated on the first plenary, we have now gone back to we have changed the order. So you may have some difficulties finding yours, but now I think you're getting there. We have a long list of speakers. Let me tell you that you may have one that it has already suffered some amendments, but there is a new one at the back of the room. So if you want to have the latest version, it's at the back of the room, although that also is changing. But at least it's a little bit more updated. So I declare open the third plenary meeting. Today we will consider agenda item 9, general debate. States are invited in accordance with Rule 50 of the Rules of Procedure of the Assembly to deliver statements of no longer than 5 minutes. 5 minutes. In order to accommodate all speakers, this time limit shall be strictly observed. Speakers will be able to see the time when they speak from the rostrum. When they see a yellow light followed by the red light, is because indeed they have spoken 5 minutes. Pursuant to Bureau decision taken on 7 September 2023, the general debate is scheduled to take place this afternoon and tomorrow in the morning. The Bureau will be meeting tomorrow morning and will inter alia consider how to allocate the additional time to the general debate agenda item. For the time being, it is only scheduled for today and tomorrow morning. I would invite delegations to please check the list of speakers. As I already told you, the new one is at the back of the room. States were able to submit written or pre-recorded statements in lieu or in addition to their in-person statements by 4th December 2023 for posting on the respective webpage of the Assembly. So states that have done so, they will have their statements posted on the webpage. So let us proceed immediately with our first speaker. Our first speaker is His Excellency Mr. Ronald Osi Lamola, Minister of Justice and Correctional Services from South Africa. You are invited to take the floor, sir.
Madam President, it is an honor to deliver this statement on behalf of South Africa. I wish to take this opportunity to congratulate the new ICC Registrar, Mr. Oslavado Zaval Gila, the new President of the Assembly, Ambassador Paiv Kokoranta, the two Vice Presidents, Ambassador Margareta Kasangana and Ambassador Michael Kanu, and the 6 members of the Committee on Budget and Finance on their election. We wish them a successful tenures, and they can be assured of our full support. The meaning of the Rome Statute should be felt by citizens of the globe who are victims of genocide and wars across the globe. Citizens of the globe where the crimes to be prosecuted are prevented by the Rome Statutes, awaiting the outcomes of this conference of state parties with hope that impunity will not be allowed to continue. As the world marks the 10th anniversary of President Mandela's passing, I would like us to revisit what he said when South Africa became a signatory to the Rome Statute. As fate will have it, a day before President Mandela's 80th birthday, South Africa was one of the first 10 nations to sign the Rome Statute. In that moment in history, President Mandela said, and I quote, "Our own continent has suffered enough horrors emanating from the inhumanity of human beings towards other human beings. I pause here to say this is the part that is often quoted. But the second component of the submission that is seldomly quoted, it may very well be because it is a question that hounds into the deep bowels of our conscience. Madiba goes on to ask this question: who knows, many of these might not have occurred, or at least been minimized had there been an effectively functioning international criminal court. Close quote. On this occasion of the 22nd session of the Assembly of State Parties, it is therefore appropriate to ask ourselves, have we fulfilled the expectations of humanity? Have we arrested the horrors of inhumanity visited upon humanity by humanity beings like you and me? Or perhaps in more direct terms, can we say that with conviction, 10 years after Madiba has transcended humanity, that we have an effectively functioning international criminal court? South Africa's positions regarding the conflict in Palestine and the Ukraine has been consistent and unequivocal, call for the immediate cessation of hostilities, unimpeded humanitarian access to affected populations, and the balanced and unbiased investigations of the crimes under the court's jurisdictions that may have been committed. We are deeply disturbed by the events that have taken place within the context of the situation in Palestine since 7th October 2023. In this respect, Madam President, it is striking that when looking at two major current and ongoing armed conflicts in Ukraine and the state of Palestine, where both situations are under investigation by the Office of the Prosecutor, we have observed far more speedy progress and indictments from the Ukraine investigation than the investigations into the long outstanding situation in the state of Palestine. Arrest warrants hover above the heads of some, but yet when it comes to the state of Palestine, the arrest warrants seems to be an embodiment of mirage. We are watching the unfolding events daily. Madam President, we must always prioritize truth-telling, even when it works against our interest. This is what integrity demands. Within this spirit, we raise our concerns about the prosecutor's conduct in Palestine. The prosecutor's statement on collaborating with the national authorities in line with the complementarity principles in his recent visits to Israel and Palestine raises questions when considered in the context of the ongoing genocide in the occupied Gaza. Additionally, the prosecutor's praises for lawyers advising the Israel government is alarming, given the gravity of the situation. It is crucial that all parties cooperate to prevent such atrocities, and the world should demand a thorough investigation into these devastating incidents. There should be no ambiguity, Madam President. The tragic actions by the State of Israel we're observing in the occupied Gaza meets the definition of war crimes and crimes against humanity and even the crime of genocide. Shamefully, it is happening in the watchful glee of the global community. We must stop it. Our concern about the unacceptable loss of life and humanity and suffering in the occupied Gaza oblige South Africa, joined by Bangladesh, Bolivia, Comoros, and Djibouti, to refer the situation in Palestine to the Office of the Prosecutor on the 7th of November 2023, fully aware that other violations in occupied Palestine have been under investigation, have been pending since 2018, with no clear way forward in sight. We call that there must be a movement, there must be investigations of these crimes that are happening without any fear or favor by the Office of the Prosecutor. Madam President, one of the challenges faced by the ICC is that it's not yet a universal court. The recent ratification of the Rome Statute by Armenia, however, sets a positive example of principle and courage that we hope will be emulated by other states that have not yet ratified the Rome Statute and joined the ICC, particularly states that play an influential role in global governance and the maintenance of international peace and security, such as the permanent members of the United Nations Security Council. South Africa knows that the Security Council retains the power to refer situations to the court in terms of Article 13b and to defer investigations or prosecutions before the court in the interest of peace and security in terms of Article 16. However, the dynamics within the Security Council may be such that neither referrals nor deferrals may be possible, to the detriment of the maintenance and the restoration of peace and security. After a quarter of a century of the adoption of the Rome Statutes, it is appropriate to consider the feasibility of devolving this power to a state party mechanism to ensure a balanced approach in the Rome Statute system. Another aspect of legitimacy that should receive urgent attention is the principle of geographic representation and gender balance within the staff complement of the court. South Africa calls on all state parties to ensure that all organs of the ICC truly represent its membership. We should honor this crucial cardinal principle, which we will engender a deep sense of inclusion for all. Madam President, we assure you of South Africa's full support during this session. We also wish to take this opportunity, as we have done before, to recognize the role that civil society has played in the court's establishment and the valuable support it continues to provide to the court to advance the objective of ensuring accountability for the most serious international crimes. Thank you for your attention.
I thank you, Your Excellency, for this statement. I now give the floor to the second speaker, His Excellency Mr. Machana Ronald Shamukuni, from Minister of Justice of Botswana.
Madam President, Excellencies, distinguished delegates, on behalf of the delegation of the Republic of Botswana, I am pleased to join other delegations at this important forum of the 22nd session of the Assembly of State Parties to the Rome Statute. As we mark 25 years since adoption of the statute, we commend the court for its contribution to the goal of ending impunity for the crime of genocide, crimes against humanity, war crimes, and the crime of aggression. I must underscore the relevance of the court and its ideals in the current global context of intense conflict and human rights violations. The prevailing global environment indicates that there is still much more work that needs to be done. However, it is unfortunate that the court, in implementing its mandate, has to contend with hostilities from certain actors. I therefore take this opportunity to register Botswana's concern at the unprecedented threats and attacks on the court and its personnel. There is no doubt that the international community will be leery of criminal proceedings against investigators, judges, and prosecutors instituted in the middle of an investigation. In this regard, cyber attacks on the court's information system undermine the efficiency and effectiveness of the court. The onus is on us as state parties to continue our resolute support for the court, especially in the face of attacks on its mandate and reputation. Madam President, in recognition of the significance of the court, Botswana ratified the Rome Statute on 8th September 2000 and the Kampala amendments to the Rome Statute on 15th April 2013. Since then, Botswana has progressively passed laws to domesticate the statute. The enactment of a law that aligns Botswana's national legislation with the country's international obligations under the Rome Statute was not without its challenges. For example, in July 2017, Parliament enacted the Rome Statute of International Criminal Court Act, which domesticated the Rome Statute wholesale. However, the 2017 Act was not commenced on the basis that some of the articles of the statute were at variance with the Constitution of Botswana. Madam President, it is important at this juncture to emphasize that Botswana has a written constitution. Therefore, any law, practice, custom, or conduct inconsistent with the Constitution is invalid to the extent of that inconsistency. I'm happy, however, to announce that in April 2023, Botswana enacted the Serious Crimes of International Concern Act. The act which criminalizes core crimes under the Rome Statute, namely crimes against humanity, genocide, war crimes, and crimes of aggression. It further excludes the application of statutory limitations for crimes under the Act. Mindful that the ICC is a complementary court created to prosecute international crimes when nations are unable to or unwilling to prosecute, the 2023 Act has provisions that extend the application of a number of national legislations such as Extradition Act and Mutual Legal Assistance in Criminal Matters Act to the International Criminal Court. The extension of the application of other laws to the court is to facilitate joint investigations, sharing of information, the principle of complementarity, and the surrender of accused persons. The 2023 Act further makes provision for cooperation with the court, including investigations and sitting of the court in Botswana, enforcement of sentences, and orders of the court in Botswana. Serving of custodial sentences in Botswana grants the court legal personality in Botswana and grants the court's judicial officers privileges and immunities. Madam President, with domestic legislation in place to investigate and prosecute crimes of international concern, what remains for Botswana is to build capacity to pursue accountability for international crimes. Therefore, for my country to completely domesticate the statute, we require targeted interventions, partnership, and technical exchanges. Through this approach, we can ensure that state parties are equipped to ensure that more serious crimes of concern to the international community do not go unpunished. Moreover, we can achieve an international criminal justice system that is effective and beneficial for all. It is our view that for the global community to be benefactors of the statute, we must all play a responsible role in the pursuit of justice. The recent geopolitical environment is a stark reminder of the importance of maintaining a robust international system that delivers justice, promotes peace and security, and ensures that there is no impunity from prosecution of international crimes. Madam President, the 22nd session is set to usher in new leadership in the executive as well as judicial organs of the court through the election of 6 judges of the court and the assumption of the new presidency and vice presidency of the assembly. State parties once again lend their voices to the international justice system. In this respect, my delegation urges state parties to fulfill their financial obligations to the court to allow it to fulfill its crucial mandate. In addition to monetary obligations, the court needs state party support through technical expertise, bilateral cooperation, and implementing decisions, to name a few. This responsibility rests solely with us as state parties. As we strive to strengthen the Rome Statute system to make it more effective and efficient, let us take note of the progress the court has made through implementation of the recommendations of the independent experts. I urge us to continue to consult and support this process and on issues such as diversity and inclusion. It is important to underscore that what makes the Rome Statute unique are the principles of universality, complementarity, and cooperation. Our presence here today is a demonstration of our mutual commitment to these ethos. We therefore call on all state parties, strategic stakeholders, including civil society around the world, to support International Criminal Court and respect its independence and the integrity of the Rome Statute. In conclusion, I wish to reaffirm Botswana's commitment and support to the ICC in the execution of its critical mandate. I thank you for your attention.
I thank His Excellency for his statement, and I now call Her Excellency Ms. Rose Mutombo Kise, Minister of State, Minister of Justice, and Garde Sceaux of Democratic Republic of the Congo.
Madame la Présidente.
Madam President, ladies and gentlemen, in your respective capacities. My country, the Democratic Republic of the Congo, that I'm honored to represent in my capacity as Minister of State, Minister of Justice, and Keeper of the Seals, under the leadership of President and Head of State, Mr. Félix Antoine Tshisekedi Tshilombo, hails the convening here in New York of the 22nd session of the Assembly of States Parties to the Rome Statute on the International Criminal Court. Madam President, the delegation of the DRC is delighted by your election to the presidency of this Assembly. We congratulate you most sincerely and wish you every success as you conduct the related affairs. We also wish to take this opportunity to warmly thank the whole team of the Secretariat of the ASP for all of their efforts ahead of this session, which will consider a number of important items, notably the election of 6 judges. As we have repeatedly recalled, the DRC, my country, is one of the states parties that have believed in the ideals of justice and peace that are upheld by the ICC. This court, which was founded in order to carry out investigations, prosecute and try the perpetrators of the gravest crimes affecting the entire international community, contributes to the struggle against impunity and to the creation of a lawful environment that seeks to ensure that these crimes do not go unpunished. Humanity in its entirety will recall that the day after the emergence of this jurisdiction, whereas it had not yet been seized of any cases, it was the DRC that was the first state to proffer its full cooperation, allowing it to take its first investigations and begin adjudication of the first cases of which it was seized with Congolese nationals. In order to demonstrate our attachment to the values of justice and our determination to combat impunity for the perpetrators of grave crimes, the DRC has distinguished itself by adopting laws that have modified certain provisions of our criminal and judicial code in order to bring it in line with the Rome Statutes, especially as regards crimes against humanity and war crimes, for which military jurisdictions now directly apply the aforementioned statute. President, ladies and gentlemen, if I may, I wish to highlight that for the last 2 decades, the eastern part of the DRC has fallen prey to grave and systematic violations of relevant rules from international human rights law and international humanitarian law. The tragic consequences on a humanitarian level of these violations that have been described as war crimes and crimes against humanity and others are the work of elements of the armed forces of Rwanda that are operating under the cover of the terrorist movement known as M23. Governed by the necessity to put an end to the impunity of these crimes, the DRC has submitted in May of 2023 a complaint to the ICC against the perpetrators of these crimes, which include Rwandan officers and military. The group of experts of the United Nations on the 16th of December 2022 reported on the perpetration of crimes and violations on its territory, especially in the zones occupied by the terrorist movement known as M23. The DRC invites all states parties to the Rome Statute to support international criminal justice that has already been seized to this effect in order to guarantee repression of these crimes that the international community also wishes to see. Furthermore, having brought its situation to the ICC in May 2023, my country received and appreciated a visit from the prosecutor of this jurisdiction on its territory, and in Kinshasa on the 1st of June 2023 signed with the Bureau of this body a memorandum of understanding in order to go deeper with existing cooperation, recalling the need for a permanent dialogue and for strong synergies in order to increase the impact of collective actions in the area of fighting impunity for grave crimes in the DRC. This MOU was signed under the aegis of His Excellency Félix-Antoine Tshisekedi Tshilombo, President of the DRC. On his behalf, at the 21st session of the Assembly of States Parties to the Rome Statute, I solemnly invited the Office of the Prosecutor to go down into the provinces of Ituri and Nord Kivu in order to take stock of the human catastrophe that had been caused by the different terrorists and criminals, especially those of M23 and their Rwandan allies. Madam President, ladies and gentlemen, I cannot fail to mention the delicate question of reparations for prejudices suffered by victims of crimes under the Rome Statute. Indeed, war crimes, the crimes of genocide and crimes against humanity have been being perpetrated for now almost 30 years in the east of my country by rebel groups supported by our neighbor Rwanda. The DRC, being committed to reparations for victims of this barbaric aggression, the Ministry of Justice that I oversee is disposed to militate for the creation of special chambers in the Courts of Appeal of my country, which could benefit from the expertise of the ICC in order to determine at the first instance and at the appeals level the amounts that should be allocated to the victims. With this in mind, the DRC is delighted to note that it has established the National Reparations Fund for victims of conflict-related sexual violence and victims of crimes against the peace and security of humanity. This public body could naturally benefit from the support of the Fund for Victims for Reparations of Justice on the basis of rulings handed down by the specialized chambers. By way of conclusion, the DRC reiterates its appeal to international solidarity with a view to bringing an end to the aggression which it has suffered from at the hands of its neighbor Rwanda. As I said earlier, Rwanda subcontracts M23 terrorists whose activism has caused the death of thousands, as well as cases of sexual violence against women and girls in particular, not to mention the pillaging of our natural resources, mass displacement of thousands of our fellow nationals who are currently far from their habitual places of residence and deprived from the ability to participate in the ongoing electoral process. On this note, the Democratic Republic of the Congo remains convinced that its message has been received and offers its full availability to cooperate closely with the International Criminal Court in order to ensure that justice triumphs. I thank you for your attention.
Je vous remercie de votre présentation.
Thank you for your statement.
Invite His Excellency Mr. Lateef Fagbemi, Attorney General and Minister of Justice of Nigeria.
Madam President, I am delighted to participate in the 22nd of the Assembly State Parties to the Rome Statute of the International Criminal Court, ICC, on behalf of His Excellency President Bola Ahmed Tinubu, the President of Nigeria. I wish to appreciate and commend the concerted efforts of the ICC and the Assembly for working round the clock to ensure that this year's meeting is a memorable and a successful one. Over the years, Nigeria has steadfastly upheld its commitment to the noble cause of the International Criminal Court, ICC, by striving to contribute to a safer and more just world. Nigeria aligns itself with the remaining 122 state parties, sharing the common goal to hold accountable those accused of war crimes, genocide, crimes against humanity, and crimes of aggression. In commemorating the significant milestones of the 25th anniversary of the establishment of the International Criminal Court, Nigeria joins fellow state parties of the Rome Statute in celebrating the court's remarkable accomplishments over the past 25 years. Madam President, I would like to take this opportunity to inform the Assembly that during the first quarter of this year, Nigeria successfully conducted its general elections. President Bola Ahmed Tinubu emerged as the winner at the polls. He took oath of office as the President of the Federal Republic of Nigeria on 29th day of May 2023. The federal government of Nigeria reaffirms its commitment to collaborate with the International Criminal Court to achieve its core mandate. These collaborative efforts is centered on upholding Nigeria's obligations within the jurisdiction of international law, with the understanding that the cooperation will be conducted in a manner that respects and preserves Nigeria's sovereignty. It will be recalled that currently Nigeria has 10 cases at the preliminary stage of investigation. Since the initiation of the preliminary examination in 2010, there has been substantial progress. This is evident in the high-level engagement between Nigeria and the ICC. In adherence to the ICC principle of complementarity, Nigeria has demonstrated that its legal system is able to investigate and prosecute anybody that commits a serious crime against humanity within its borders. In this regard, all arms of government are collaboratively working together to strengthen internal mechanisms and processes within the judiciary and relevant agencies. The ultimate objective is to impartially dispense justice to deserving victims. I wish to inform that in anticipation of inquiries on these cases, a focal office has already been established in the Federal Ministry of Justice to provide updates and address queries in real time. In addition, my delegation takes this opportunity to reassure that Nigeria has the political will and judicial capacity to bring these cases to a close. Madam President, my delegation strongly condemns the recent cyber attacks on the digital space of the ICC in September 2023. These attacks were a blatant attempt to undermine the court's mandate, and we hope that the perpetrators will be held accountable for their actions. We commend the court's efforts to fully digitize its processes. We hereby urge the ICC to collaborate with relevant stakeholders that have dealt with risk arising from rapid advancements in technology, especially the use of artificial intelligence, in order to effectively prevent future cyber attacks. Nigeria would like to urge state parties to fully support the court's 4 strategy plans for the period 2023-2025, launched in June 2023. These plans are aimed at ensuring that all the organs of the institution are harmoniously working together as one entity to achieve the core mandate of the ICC in an efficient and effective manner. In the light of the ICC's budgetary constraints, Nigeria would like to encourage the court to adopt cost-effective measures in implementing its strategic plans. The inclusion of key performance indicators of the ICC strategic plans will further enable the court to assess the performance and progress made by each organ. Madam President, on the publication of Reuters news agency titled, quote, "Nightmare in Nigeria, a conflict waged on the lives of women and children," unquote, I wish to restate that the National Human Rights Commission, which is an independent and impartial commission established in line with the Paris Principles, is currently investigating the allegations. However, there are concerns about the refusal of Reuters to support ongoing investigations into these issues. The government awaits the conclusion of investigations by the Human Rights Commission. Nigeria is also unrelenting in our effort to partner with neighboring countries and other members of the international community in the fight against terrorism. I would therefore like to use this opportunity to reassure that Nigeria has the political will and capacity to bring these cases to a close. Madam President, I also wish to inform that Nigeria on the 20th of February 2023 ratified the Convention on Cluster Munition, which came into effect on the 1st of August 2023. The Convention not only prohibits the use of production, transfer, and stockpiling of cluster munition, but also the assistance or encouragement of anyone to engage in these prohibited activities. The continued use of cluster munition globally causes widespread human suffering and negatively impacts national and international peace building and humanitarian assistance efforts, in addition to other severe consequences that can persist for many years after use. Nigeria believes in the promotion of its universalization and its full implementation and calls on state parties to ratify this important convention which can reduce war crimes. My delegation congratulates the 6 newly elected judges from the 14 nominees representing the regional groups of the world. Given their pedigrees, we have every reason to expect that they will ensure fair, equitable, just, and speedy dispensation of justice in all global mechanisms set up for combating serious crimes. In the same vein, we congratulate the outgoing 6 judges for completing their 9-year term successfully, while commending them for their significant contributions to the reformation of the court. We wish them the very best in their future endeavors. In conclusion, Nigeria stands firmly with the fellow state parties to the Rome Statute in the collective endeavor to end impunity for the perpetrators of the most serious crimes affecting the international community and supports fully the work of the court. Nigeria also calls on state parties that have not yet acceded to the statute to do so. Madam President, I thank you for your kind attention. Thank you.
I thank His Excellency for his statement, and now I invite His Excellency Mr. Riyad Mansour, Minister, Permanent Observer to the United Nations of the State of Palestine.
Madam President, Excellencies, ladies and gentlemen, why did we establish the ICC? The answer is in the Rome Statute. It states, mindful that during this century, millions of children, women and men have been victims of unimaginable atrocities that deeply shock the consciousness of humanity, and determined to put an end to impunity for the perpetrators of these crimes and thus to contribute to the prevention of such crimes. Which crimes is it referring to? Aggression, war crimes, crimes against humanity, and genocide. The unimaginable atrocities that deeply shock the conscience of humanity being committed against children, women, and men in the Gaza Strip by Israel for 2 months now. 2.3 million Palestinians have spent every day of the last 2 months trying to survive, besieged, bombed, with nowhere to go, asked by the killers to move from one place to the next, to be killed here and there, North and South, no place is safe, no one is spared. Israel has admitted several times now that it is denying access to humanitarian assistance as a method of war. It was aware of the horrific number of people that were going to be killed in its bombardments and considered that was an unacceptable number. 16,000 Palestinians, including 7,000 children. A justifiable number? This is the mindset of war criminals. Israel states that it is observing international law, an international law nobody has heard of, one that allows the killing of entire families in their sleep, one that allows indiscriminate attacks, one that allows bombardments that are killing primarily and often only civilians. 70% of those killed are women and children. One that allows besieging millions of people, depriving them of objects essential to their survival. The entire international criminal law relies on a single premise. There is no justification for such crimes. We have joined the ICC 9 years ago, at a time where crimes had been committed for decades, and the crimes continued being committed for 9 years since, and not a single arrest warrant has been issued yet. This is a failure to deliver justice to victims and failure to deter the perpetrators. Gaza makes any further delay unacceptable, unjustifiable, unforgivable. Israel has effectively destroyed every single requirement for life in the Gaza Strip while the entire world was watching, and it is still shelling neighborhoods as we speak. It has made of hospitals and UN shelters and mosques and churches its primary targets, and it has made of children, of the sick and the wounded, of the vulnerable, its primary victims. Why did we adopt the Rome Statute if not to protect these people? There is no credibility without consistency. One cannot say taking of hostages is a crime and fail to mention 2 million Palestinian hostages. One cannot show outrage for attacks against civilians and not be outraged by the attacks against hundreds of thousands of Palestinian civilians. We have extended our full cooperation to the prosecutor and his office and spared no effort to help the investigation move forward. The prosecutor was met by the Palestinian leadership and government at the highest levels in recent days and by some of the Palestinian victims of Israeli crimes. Had he visited Gaza or any part of the West Bank, including East Jerusalem, he would have seen Palestinian victims wherever his eyes laid sight. At the occasion of this visit, the anger and frustration of the Palestinian people with the ICC was more than evident. The credibility and authority of the court are facing their greatest test with the situation in the state of Palestine. A test of the court cannot afford to fail. If this institution embodies double standards and both sidism instead of delivering justice to the victims who need it most, I remind here that this is a court of last resort, and Palestinians have no other resort. If it fails to deliver justice to Palestinians now, when it still matters, if it fails to hold perpetrators accountable, those who are most responsible for the most serious crimes, the Israeli leaders, it will fail our people, but also its sacred mission. Finally, Israeli settlements, which imply the commission of war crimes and crimes against humanity, are built by official decisions taken at the highest level, funded from the Israeli budget. Israel has provided the court with evidence of its crimes day in and day out. They are available online, together with clear and unambiguous confessions by Israeli leaders. Settlers' violence is only one manifestation of this overall criminal enterprise. What is taking so long to start prosecuting those responsible for the crimes related to settler colonialism as well? Israel is defying this court from its prime minister to its soldiers. It is showing the deepest contempt for the law and the court established to protect it. They are confident they have nothing to worry about. We want to remain confident the court will prove them wrong. For 9 years now, they were right and are acting accordingly. Anyone who wants to see an end to these crimes and prevent their reoccurrence must start by giving the signal that this era of impunity has lasted long enough and killed way too many Palestinians and is finally over. There is one law, one set of rules for all, regardless of the identity of the victims or the identity of the perpetrators. We said 9 years ago, we are joining the court because we are seeking justice, not vengeance. Aren't the Palestine people entitled to justice? Every country here, some sooner than other later, have come to say that what Israel is doing is unacceptable. What are they willing to do to stop it? That is the only question that matters now. How do you stop the assault on Palestinian children, on our civilians, on our lives? How do you make Israel cease fire? You don't ask, you act. That is how. That is the duty of the court. That is the duty of every state. That is the duty of everyone. And I thank you very much, Madam President.
Thank His Excellency for his statement. And now I invite to take the floor His Excellency Mr. Arnaud Dubaye-Abazen, Minister of State in charge of Justice, Promotion of Human Rights and Good Governance, Garde des Sceaux of the Central African Republic.
Madam President, ladies and gentlemen, members of the office, ladies and gentlemen, on behalf of the CAR, which I represent, I extend my sincere thanks to the eminent members of the Office of the Assembly of the States Parties for holding this meeting under the ICC and the Rome Statute for International Cooperation. In particular, I would extend my warmest congratulations to you, Madam President, on your election, as well as the election of the other elected members, distinguished delegates, ladies and gentlemen. The CAR, as a member of the ICC, believes that in creating this court, the international community placed a great deal of hope in eradicating serious international crimes, including the crime of genocide, war crimes, crimes of aggression, and crimes against humanity. The CAR has also, with the support of the international community, set up a hybrid international court to try similar crimes in accordance with complementarity. Just a few weeks ago, the Office of the Prosecutor of the ICC signed a memorandum of understanding with my government and another with the Special Criminal Court to bolster cooperation and synergy in our activities. And I think it is necessary to recognize the fact that the ICC, set up more than 20 years ago, has made a great deal of progress, which we should highlight, even if it falls sometimes prey to criticism. There are geopolitical and geostrategic positions at stake here, and there are serious risks of shattering everyone's hopes if we do not succeed. The report submitted by the President and the Prosecutor of the ICC calls for us to overcome the gaps in the current jurisdiction. Distinguished delegates, the CAR, my country, has deferred a number of cases and handed them over to the ICC, and we place particular importance in cooperation, and we hope that states, parties, and the international community will do everything possible to avoid the errors of the past, which had weakened the precursor to the United Nations, the League of Nations, and which had led to the loss of human lives. The government of my country firmly hopes that the time has come more than ever for us to rethink the Rome Statute so that we can make this international criminal jurisdiction even more effective and more independent, so that it is sheltered from any geopolitical or geostrategic challenges. We believe that necessary assistance must be given to the ICC so that we can have a more prosperous and peaceful world. Before concluding, Madam, I would like to extend my warmest congratulations to the 6 new judges who've just been elected to the ICC, and I wish them every success. Thank you.
Je vous remercie, and now I invite His Excellency Mr. Alphonse Charles Wright, Minister of Justice and Human Rights, Garde des Sceaux of Guinea.
Madam President, Prosecutor of the International Criminal Court, ladies and gentlemen, representatives of the states parties, observer members, the Republic of Guinea has the auspicious honor of participating in this 22nd session of the Assembly of States Parties to the Rome Statute. This participation, as others have said, is the sign of the importance for our country of the implementation of the Rome Statute for better integration of the principles that underpin international criminal justice at the heart of this great family of the United Nations. As I am speaking to you now, our country, the Republic of Guinea, is arranging one of the processes that is considered, thanks to the enlightened vision of the President of the Republic, Colonel Mamadi Doumbouya, to erect itself as a model for success across Africa and even internationally. Under his leadership, Guinea has taken a path in signing a memorandum with the Office of the Prosecutor of the ICC to ensure that any breaches committed at the time of events the 28th of September 2009 be tried through its own judicial institutions thus putting an end to many years of inertia, 13 years since the attacks, with 157 people killed and more than 106 women raped. These acts have been attributed to some elements of the defense and security forces under Thaddeus Camara. This trial, which began on the 28th of September 2022, has been exclusively financed by the government of the Republic of Guinea with technical support from the United Nations system, with the presence of Mr. Karim Khan. And I welcome him here, and I encourage him to continue his actions against impunity. I thank you, sir. Ladies and gentlemen, there is no doubt that in beginning this trial, just 1 year after his accession to the Supreme Judicial Chambers of my country, and following 13 years of inertia, the President of the Republic wished to send a strong signal to the international community that by ratifying the Rome Statute on the 14th of July 2003, we are clearly focused on a future which involves a committed struggle against impunity for international crimes. This means that all international crimes committed on its territory, complicit victims that are Ghanaian nationals, will be, independently of the nationality of the perpetrator or the place where the crime was committed, can be arrested in the country. The in Conakry, outside any kind of legal procedure, the awful psychological and physical trauma must be addressed. The response of the Ghanaian state was immediate, and we were able to drive out the assailants and ensure reinforced protection for the victims and the witnesses. To date, a judicial investigation has been opened, and national opinion shall be informed at the appropriate time of its conclusion, which I believe should identify those responsible. This unfortunate incident should draw the attention of the international community as regards support in order to ensure that this trial can actually be conducted properly, and to seek out Mr. Claude Pivy in order to ensure that information exchange and arrests can bring him before the criminal court. In light of the risks undertaken and the technical and financial support, it is crucial at this phase in order to guarantee that the trial is conducted in strict adherence to the law and human rights. To this end, it will be necessary for the government and its partners to convene a coherent plan of action with precise and achievable timeframes. The application, successful enforcement of the principle of complementarity with the ICC would represent a victory both for Guinea, for justice, and the international community. I thank you.
Je vous remercie. And now I invite His Excellency Mr. Erkki Kodar, Vice Minister of Foreign Affairs of Estonia.
Madam President, distinguished delegates. Estonia aligns itself with the statement that will be made on behalf of the European Union and its member states. This year we celebrate the 25th anniversary of the adoption of the Rome Statute of the International Criminal Court. Since its establishment, the ICC has played a vital role in the promotion of international criminal law, ensuring accountability for the most serious international crimes, and delivering justice to the victims of atrocity crimes. Estonia reconfirms its continued and strong support to the ICC and to the court's mandate. We condemn the attempts made to undermine the ICC and the system of international criminal justice, including the recent series of cyber attacks against the ICC. In this context, we particularly support the initiative of the Registrar to establish a special fund for security to address the urgent need to invest in IT and cybersecurity systems. Estonia deplores the criminal proceedings initiated by the Russian Federation against the prosecutor, the president, and the judges of the ICC. This is an outrageous reaction to the ICC's arrest warrants against Vladimir Putin and Maria Lvova-Belova for the alleged war crimes of unlawful deportation and transfer of children from Ukraine to the Russian Federation. This is a clear attempt to obstruct the ICC's investigations and an attack against the ICC's independence, impartiality, and legitimacy. The issuance of arrest warrants was an important step towards accountability for atrocity crimes committed in Ukraine. Estonia commends the ICC for the establishment of the country office in Ukraine. As the ICC does not have jurisdiction over the crime of aggression in Ukraine, discussions should continue how to hold Russia's political and military leadership accountable for the crime of aggression and to establish an international ad hoc tribunal with that aim. At the same time, we need to amend the Kampala Amendment on the crime of aggression to harmonize the ICC's jurisdiction over core crimes, as all 4 Rome Statute crimes are crimes under general customary international law. The perpetrators of crime of aggression should be brought to justice wherever and by whoever it has been committed. Estonia fully supports the ICC, financially, politically, and with expertise, especially to cope with the rapidly growing workload. Currently, 3 experts seconded by Estonia work in the Office of the Prosecutor, and the workload of the court is continuously growing, including investigation into the situation in the state of Palestine, which extends to the escalation of hostilities and violence since the attacks that took place on the 7th of October this year. Estonia calls upon all state parties to seriously consider increase the budget for 2024 to allow the court to efficiently fulfill its tasks. We encourage all states to make payments at the earliest possible time, and states that are in the arrears to take steps to eliminate those. Madam President, for many years, Estonia has been a regular donor of the ICC Trust Fund for Victims, whose important work offers reparations and assistance to victims, their families, and their communities. A considerable number of individuals have already benefited from the programs, but the Trust Fund needs continuous support. Estonia would like to repeat a call for all states and other stakeholders to support the Trust Fund for Victims. The universal acceptance of the Rome Statute and its amendments remain a challenge to the international community. We are glad that Armenia has deposited the instrument of ratification, and the Rome Statute will enter into force for Armenia on the 1st of February 2024. Estonia warmly congratulates Armenia for becoming the 124th state party to the Rome Statute. Estonia repeats the call on all governments that have yet not ratified the Rome Statute and its amendments, including the crime of aggression, to do so in order to further strengthen the system of international criminal justice and enable it to provide a truly universal protection. Estonia has initiated the ratification amendments to Article 8 of the Rome Statute, and these are currently pending before the Parliament. We hope to finalize this process at the beginning of the next year. And final words on the election of judges. Firstly, I would like to congratulate all those candidates that have been elected. We are very proud to have nominated such a highly qualified candidate, as concluded by the ACN, as Mr. Andres Parmas. International law and ICC, as its reincarnation, it is crucial for small states, and we nominated a candidature in good faith as a small state for whom it would have been the first time to have a judge on the panel. If there was a trophy for stability, we would get that with our stable support, but unfortunately, it was not enough at this time. I want to express my utmost gratitude to all those that promised us their support and actually delivered, and thank you for believing in us. We have supported the ICC, we will continue to do so, and sooner or later, you will have to consider our candidate again. Thank you.
I thank His Excellency for his statement. I now invite Her Excellency Ms. Gabija Grigaitė-Daugirdę, Vice Minister of Justice of Lithuania.
Madam President, Excellencies, ladies and gentlemen, while aligning with a statement by the European Union that will be delivered later, it is a great privilege for me to address the Assembly in the national capacity of Lithuania. First of all, I would like to reiterate Lithuania's continuous and unwavering support to the International Criminal Court. We strongly condemn any threats against the court and its personnel, in particular arrest warrants issued by the Russian Federation against officials of the court. Lithuania stands firmly by the court with full confidence in its crucial role. Today, we discuss the future of the International Criminal Court at the headquarters of the United Nations, the principal institution for defending international peace and security, human rights, and freedoms. The aggression against Ukraine is a test case for everything that United Nations and International Criminal Court were established to stand for, that is justice, peace, and accountability for international crimes. Power to break the rules does not take from us the power to respond by law, overcoming aggressors' expectations of inaction. When international law becomes hostage of the aggressor state in the United Nations Security Council, all hopes for international justice are vested in judicial institutions such as International Criminal Court, because there is no immunity from International Criminal Court law. Wherefore, understanding that international crimes shall not go unpunished obliges us to continuously strengthen the capacities of the International Criminal Court in exercise of its jurisdiction, and at the same time obliges us to reconsider the court's role and jurisdiction over the crime of aggression. Lithuania calls the Rome Statute states to address the issue and commits itself to participate and support the process for a negotiation of the court's jurisdictional limits over the crime of aggression. However, aggression that Russia continues to wage against Ukraine demands a legal response now. That is why Lithuania has been constantly advocating for the establishment of an international criminal tribunal for the aggression against Ukraine. We do have understanding that establishment of such special tribunal is vital for ensuring that the crime of aggression does not go unpunished, whether it takes place in Ukraine or elsewhere. Universal reach of the International Criminal Court is crucial for its effectiveness and impact, but only coherent accountability approach consisting of a special tribunal for the crime of aggression against Ukraine, together with necessary changes in the Rome Statute, can bring us closer to the dream justice. I truly believe that all the discussions around the crime of aggression bring us one step closer to the universality of the International Criminal Court as institution of the last resort for all international crimes being committed around the world. Madam President, distinguished delegates, law used to fall silent in times of war. The ICC made it clear that international criminal law does not. The justice for thousands of victims of international crimes must be real, because international crimes are concepts with legal consequences. Arrest warrants do demand courage from the court, and I commend the prosecutor for his active role and encourage to continue in the same vein. But now, the courage and political will is needed from all of us for enforcing arrest warrants and making sure that justice does have the possibility to become visible. Let me also address a few more issues concerning engagements of states. First, I call for the strong and sustainable financial support for the International Criminal Court. The justice has costs, and we must cover them. Wherefore, Lithuania fully supports increasing the budget of the court. Second, the ICC entered uncharted area while issuing arrest warrant against the head of Russia. For this reason, the court has to invest in the additional means for making sure that all sensitive data of investigations is duly protected. Third, I call the Assembly for a victim-centered approach to support every instrument and initiative which puts the rights, dignity, safety, and well-being of victims at the forefront. Fourth, at this Assembly, we are a community with the same values, wherefore expectations for justice of every region, every country, and for every situation are important, because sustainable justice can work only with the same standards and guarantees across the regions. To conclude, let me assure Lithuanians' constant commitment to all the initiatives strengthening the International Criminal Court. International criminal law is the peace project, wherefore the responsibility to defend peace and justice, to protect human rights, and to work towards a safe future is our main goal, rooted in our difficult history. But even during years of occupation by Soviet Union, Lithuania has never lost faith in international law and will continue working towards restoring trust in international law and justice, because from our history we know that the time and the right moment is of essence for justice. Thank you, Madam Minister.
Thank Her Excellency for her statement, and now call His Excellency Mr. Marko Stučin, State Secretary, Deputy Minister for Foreign Affairs of Slovenia.
Madam President, Excellencies, ladies and gentlemen, Slovenia aligns itself with the statement by the European Union and its member states and would like to further contribute to the general debate in its national capacity. This year we took stock of the achievements and challenges the ICC has faced so far. And we can once again, with a heavy heart, see that the court is needed more than ever, and that it even has to cope with the serious attempts to obstruct its work. Every judicial institution should be able to operate independently and impartially, investigating and establishing accountability in accordance with laws and regulations. Slovenia would like to reiterate its support for the ICC and its mission to the benefit of the entire international community, and deplores any interference in the work of the court. When we think of the values enshrined in the Rome Statute, we should not forget that every atrocity is unacceptable and that suffering of every victim is inadmissible. This must guide the work of the court as well as the support of the states to ensure that all situations are addressed equally, including the situation in the state of Palestine, Ukraine, or in other situations. Engagement and inclusive dialogue among different stakeholders makes the international criminal justice ecosystem with the ICC at its core more efficient, resilient, and better overall. Slovenia acknowledges the tireless effort of civil society in this regard. Active engagement in full and prompt cooperation with the court, as well as among the states parties and with other states and international organizations, is crucial to safeguarding the foundations of international peace and security. Slovenia is pleased that the adoption of the Ljubljana-The Hague Convention on the 26th of May this year filled an important legal gap. This landmark treaty will strengthen international legal cooperation in the investigation and prosecution of international crimes. Madam President, one of the most important features of the Rome Statute is that it gives victims the opportunity to be heard and to seek redress. Slovenia is committed to recognizing their rights and providing them with the assistance. It has supported the Trust Fund for Victims in the past, and it also made a contribution this year. In order for the court to fulfill its mandate and to be active in all the situations it is dealing with, it is in need of sustainable and predictable funding. A lack of sufficient resources should be avoided and should not lead to decisions to limit its activities or reduce the objectives and standards set. This is a prerequisite for meeting the expectations of states parties in pursuit of justice. Distinguished delegates, allow me to express my sincere gratitude for the dedication and professionalism of the President of the Assembly, Silvia Fernandez de Gurmendi, the President of the Court, Piotr Hofmansky, and the Director of the ASP Secretariat, Renan Vilasis. Throughout their term of office, their work has left its mark, and it has been a privilege, also my personal privilege, to cooperate with them and their teams. And as we say goodbye to some individuals, it is time to look forward and welcome a new state party, Armenia, into our midst. We hope that this decision will encourage other states to ratify or accede to the Rome Statute and bring it closer to universality. I would also like to extend congratulations to the newly elected President of the Assembly, Päivi Kaukoranta, two newly elected Vice Presidents of the Assembly and members of the Bureau. As one of the new members of the Bureau, Slovenia will continue to contribute to the benefit of the ICC and the Rome Statute system as a whole. And finally, I would like to congratulate the newly elected judges of the court, including Ms. Betty Hochler, nominated by Slovenia, because the ability of the court to successfully exercise its jurisdiction depends on the professional competence, dedication and skills of its elected officials, in particular the judges. I wish them all every success in the performance of their duty. I thank you.
I thank His Excellency for his statement, and now I invite His Excellency Mr. William Castillo, Vice Minister for Anti-Blockade Policies of the Bolivarian Republic of Venezuela.
Señora Presidenta.
Madam President, Venezuela is firmly committed to legislation and to practice and to protecting and promoting all human rights and fundamental freedoms. And we therefore express our categoric rejection for crimes against humanity, war crimes, genocide, and ethnic cleansing, all codified in the Rome Statute. We also reiterate the key role of states to establish and ensure human rights for their people, and our support for efforts aimed to ensure that justice is served in those cases where atrocious crimes have been committed, always basing ourselves on the primacy of national jurisdiction. Having said that, the Bolivarian Republic of Venezuela reaffirms its firm commitment to the Rome Statute and to combating impunity in the face of international crimes, aware of the fact that this is an essential step both for the maintenance of international peace and security and also to promote the rule of law worldwide. Madam President, our country is firmly convinced that the ICC is a court of last resort for international crimes, serious international crimes, beyond national jurisdictions, and therefore the authorities have the key role to investigate and to prosecute crimes that are codified in the Rome Statute. And the court will only become involved when the states are not prepared or are unable to act within their jurisdiction to carry out prosecutions. This is the spirit underpinning the Rome Statute, and given the clear lack of will of the authorities of the United States of America to investigate and to establish criminal responsibility for those who commit with impunity for more than a decade now crimes against humanity because of the unilateral coercive measures it applies against our people. More than 30 million Venezuelans are suffering from that. In 2020, we therefore reviewed the background to the prosecutor's office and asked for a review of Article 7 of the statute. In the case of Palestine, where for years, with impunity, major crimes against humanity and war crimes have been committed, and today the occupying power, the occupying country is committing, in the eyes of the entire world, ethnic cleansing in order to exterminate the Palestinian people. This is true genocide, costing the lives of thousands of innocent people, including women and children. And states parties to the statute cannot remain silent in the face of this. Having said that, Venezuela supports the views expressed by a group of countries just a few weeks ago to put an end to aggression and ensure accountability. We welcome the announcement made by the prosecutor of the court to have a new post within the office to devote himself or herself exclusively to the Palestinian case, and we hope that the court will work as quickly as it has in recent cases in order to have tangible results and to put an end to years of suffering and pain for the Palestinian people. Similarly, we also hope that there will be an end to any delays, including lack of resources, so that once and for all, the prosecutor of the court can begin investigations on the so-called Venezuela II case. Madam President, our freedom fighter, Simón Bolívar, said that there are essential values such as equality, which we must recognize, and therefore our country categorically rejects any efforts to use international actions, including the Rome Statute and the work of the court, that will only favor political interests and which run counter to instruments and undermine the credibility and the integrity of the court and the primacy of justice and human rights. We also take this opportunity to reiterate that all of the claims put forward by our country during our claims 4 years ago or 4 weeks ago are proof of the fact that we are a responsible member of the international community and we are prepared to comply with our international obligations, including the guarantee of human rights. And our country would never carry out crimes against humanity. Having said that, despite the efficiency of the court, both in addressing the Palestinian issue, rather the slow pace of the cases such as Palestine and Venezuela, we believe that when certain decisions were adopted, our country and other institutions, despite that slow pace, remain committed to the Rome Statute and the ICC. A memorandum of understanding was signed to establish the framework for the Office of the Prosecutor to have a hub in our country to provide technical assistance to our ministry to bolster our capacity, including investigations and prosecutions for crimes that are codified in the Rome Statute. Madam President, finally, since the Bolivarian Republic of Venezuela has ratified and assured, has made certain that we will ensure that victims, that there are reparations for victims internationally. We call for the preservation of the independence, the objectivity, non-selectivity, the impartiality, and the transparency of the work of the ICC. And we reject any attempt to promote legal wars, the so-called loafers, and put an end to the politicization of justice so that genuine efforts can be made to find the truth and to make sure that those who perpetrate international crimes are held accountable before justice. Thank you.
Muchas gracias.
Thank you very much.
Agradezco a Su Excelencia.
I thank Your Excellency for your statement. And I now give the floor to Her Excellency Ms. Ana Jiménez de la Hoz, Deputy Permanent Representative to the United Nations of Spain, on behalf of the European Union.
Señora Presidenta.
Madam President, I am honoured to address the Assembly of States Parties on behalf of the European Union and its member states. The candidate countries North Macedonia, Serbia, Albania, the Republic of Moldova and Bosnia-Herzegovina, the potential candidate country Georgia, and the EFTA country Norway, member of the European Economic Area, as well as Andorra and San Marino, align themselves with this statement. Marking the 25th anniversary of the adoption of the Rome Statute, the EU foreign ministers on the 26th of June reiterated the European Union's and its member states' unconditional support for the International Criminal Court, the ICC, and reaffirmed their commitment to promote the principles and values of the Rome Statute and defend the court's independence. We will count on the court to bring justice wherever needed across the world in situations under its jurisdiction, in line with the principle of complementarity, as well as reparations to victims. All situations where the most serious crimes of concern to the international community appear to have been committed deserve equal attention. At a time when international criminal justice is needed more than ever, the ICC, its judges and its staff continue to face unacceptable attacks and threats from those who seek to prevent the enforcement of international law. Any threat or attack against the court, its personnel or those cooperating with it, its systems and its independent functioning are unacceptable. The European Union will continue to provide its full support and contributions to ensure the protection of the court and of its staff against external pressures or threats. We also urge all states to support and protect human rights defenders and civil society organizations who work to bring justice to victims. Threats and intimidation directed at civil society organizations cooperating with the ICC are unacceptable. Madam President, we urge all states to cooperate with the ICC, including by granting access to the prosecutor and his office to conduct investigations and also for the execution of arrest warrants. In this regard, we urge all states to refrain from any action that would frustrate the activities of the court or undermine its decisions. Adequate and sustainable resources are needed to enable the court to fulfill its mandate and respond to the increase in its workload. We therefore urge all states parties to provide the ICC with necessary financial resources and to fulfill their obligation to pay their annual contributions in full and on time. We commend progress made in the review of the International Criminal Court and the Rome Statute system. We encourage the ICC and states parties to conclude the assessment and to continue working on the implementation of the recommendations of the independent experts while preserving the integrity of the Rome Statute and respecting the prosecutorial and judicial independence of the court. We place particular importance on promoting good governance and a healthy work culture that ensures inclusion, geographical representation and gender equality. The EU also calls on states parties to contribute to the Trust Fund for Victims, as it plays an essential role in providing justice by ensuring that thousands of victims receive reparations and essential assistance. Madam President, the universal ratification of the Rome Statute remains our ultimate goal. The EU congratulates Armenia on having recently ratified the Rome Statute. The EU and its member states will continue to promote the ratification and full implementation of the Rome Statute through the various means at their disposal, encouraging all countries that have not yet done so to accede to the Rome Statute in order to end impunity for the most serious crimes worldwide. The EU further invites states parties, having considered their national circumstances, to consider whether to ratify or accept the amendments to the Rome Statute. Madam President, we have very high hopes for the ICC. We look forward to the next 25 years and to what the court can and will accomplish for the victims and for future generations and for justice. I thank you.
Muchas gracias.
Thank you very much.
I invite Ms. Monica Furnes from Director Legal Affairs Departments of the Ministry of Foreign Affairs of Norway.
Madam President, let me start by thanking you for your important work as President for this Assembly over the past 3 years. Norway has been a steadfast and strong supporter of the ICC since its establishment. We look forward to welcoming Armenia as the 124th state party to join the statute. Norway will continue to work for universal ratification of the Rome Statute. This summer, we celebrated 25 years of the statute. ICC's mandate remains as important as ever. Over the last years, we have seen new and old conflicts igniting, with serious breaches of international law and terrible human suffering. We are equally concerned no matter where atrocities happen. Impunity increases the risk of conflict recurring. Ensuring accountability is how we create long-term peace. Victims must be reassured that justice will be served. And those committing atrocities must know that they will be held accountable, either in national jurisdictions or at the ICC. As a court of last resort, the court's work on complementarity is essential. These last years, the court has tackled a record workload. The court is also facing increasing attacks, threats, and security concerns. This is unacceptable. We will continue to defend the court from any attempts to undermine it, and we thank the court's officials and staff for their work under these circumstances. Madam President, the court needs to be properly funded. As states parties, we must ensure that the court has the resources to meet increased demands. A robust regular budget enables the court to plan and prioritize its work. This is crucial to protect the court's and the prosecutor's independence, to ensure that investigations and cases are not politicized. The changing nature of security threats against the court is another argument in favor of increasing the regular budget. Norway seeks to promote a strong, effective, and independent court. Continued implementation of the review recommendations is important in this regard. In light of the court's exceptional workload and external pressure, improving governance of the court is crucial. Improved working culture, gender equality, and integrity are key aspects that Norway will continue to follow closely. Madam President, as Norway ends our term on the Bureau, we remain convinced of the responsibility states parties have in gearing the ICC for success, through political, financial, and practical support. This extends to our cooperation with the court in giving access to our territories, cooperating with investigations, and supporting enforcement. And it includes our work here at the Assembly. We look forward to productive discussions on how to advance the fight for global justice. Thank you.
I thank you for your intervention, and now I invite Her Excellency Ms. Sandra Lendenman-Winterberg, Deputy Director of the Directorate of International Law of the Federal Department for Foreign Affairs of Switzerland.
Madam President, thank you. The current climate reminds us that we need the International Criminal Court more than ever in every region of the world. Combating impunity and seeking justice are key components for peace, security, and lasting reconciliation. The court therefore deserves the unwavering support of states parties who have come together in this room today. We are prepared to commit to that goal so that this Assembly can take the necessary decisions to bolster the court and the system of the Rome Statute effectively and significantly. My delegation would like to address 4 specific points. The first involves our role as states parties in our support for the ICC. We must defend the ICC when it is subjected to external pressure and to security risks. We must firmly condemn threats and measures taken against officials of the court, to recall the independence of the court, and finally, to support the ICC by fully carrying out the obligations that we have, the first being the obligation to cooperate and to implement many pending arrest warrants. States must be consistent in our work with the court. As the prosecutor recently said, we are facing a pandemic of inhumanity from Darfur to Ukraine, from Afghanistan to Myanmar, and in the tragedy which is worsening in Israel and occupied Palestinian territories. We must recall that in each of these situations, the court has jurisdiction. The situation in Palestine is the subject of an investigation and has been since March 2021, and this extends to the attacks of 7 October 2023 and the escalation of hostilities and violence which ensued. It underscored that the court has a jurisdiction both for crimes committed on Palestinian territory as well as crimes committed by Palestinian citizens, including in Israel. As states parties, it is up to us to support the court's efforts in this situation, as in others, and to respect its independence and its impartiality. Secondly, the court needs universal support, and we welcome the recent ratification of the Rome Statute by Armenia, and we call upon all states which have not yet done so to ratify the statute, as well as its amendments related to war crimes and crimes of aggression. These ratifications will reinforce victim protection and will promote the uniform implementation of the Rome Statute and make it possible to prosecute all crimes under its jurisdiction, regardless of where those atrocities are committed or who the perpetrators are. Thirdly, we must pursue our efforts to bolster the Rome Statute, in particular in the area of the crime of aggression. Victims have a right to that. To achieve this goal, it now seems necessary to harmonize the rules of jurisdiction of the ICC so that the crime of aggression can be prosecuted on an equal footing with other crimes under the Rome Statute. Given this necessity, we cannot await the review conference on amendments related to the crime of aggression to be held in 2025. We must begin discussions without delay to remove any obstacles which keep the court from exercising its jurisdiction on this particularly serious crime. Madam President, the final point I wish to mention has to do with the budget. Switzerland insists on the need to earmark sufficient resources for the court. In point of fact, combating impunity cannot be done without sufficient financing. At the same time, we expect that the court will make the best possible use of the means available to it. Madam President, the states parties have a key role to play so that the court can successfully carry out the mandate which we have entrusted to it. Thank you.
Je vous remercie.
Thank you.
Invite His Excellency Mr. James Larsen, Permanent Representative to the United Nations of Australia.
Thank you, Madam President, distinguished delegates. At the outset, let me express Australia's sincere appreciation to Silvia Fernandez de Gomendi for her contribution as President of this Assembly over the past 3 years. I also commend the 6 departing judges of the International Criminal Court for their distinguished service over many years and welcome those elected this week. Madam President, Australia has remained a steadfast supporter of the International Criminal Court and its mandate to ensure accountability for serious international crimes. We condemn recent cyber attacks against the court. We also condemn the unacceptable attempt by Russia to intimidate the court's personnel by issuing arrest warrants against them. These efforts to hinder the court's work will not succeed. They will not deter the international community's commitment to justice and accountability. Nor will they succeed in undermining the important role the court has to play in this regard. They only strengthen our resolve and our commitment to safeguarding the court's integrity and independence. Madam President, we express our appreciation for the court's continued commitments to its mandate over the course of this year. We welcome the prosecutor's release of papers on sexual and gender-based crimes and crimes against children. We also welcome the prosecutor's acknowledgement that particular conduct committed in cyberspace may contribute, facilitate or amount to international crimes under the Rome Statute. Australia has long recognised that international law, including international humanitarian law and international criminal law, applies in cyberspace. We welcome the prosecutor's commitment to collect and review evidence of relevant cyber conduct and share such evidence with national authorities to support domestic prosecutions. Madam President, the principle of complementarity is at the heart not only of the court's mandate but also its success. The court cannot be judged solely by the number of convictions that it records, but also by the impact it has on individual states and their own efforts to combat impunity. As we can see, that impact continues to be significant. Australia believes that accountability begins at home. We commissioned a robust national inquiry into allegations of serious international crimes by Australian Defence Force personnel in Afghanistan. We have established an Office of the Special Investigator, a civilian body, to investigate such alleged crimes alongside the Australian Federal Police. We have been encouraged by the International Criminal Court's Office of the Prosecutor's productive engagement, which reflects the commitments enshrined in the preamble of the Rome Statute of effective national prosecutions, international cooperation and complementarity. Australia's work in this regard is ongoing and will take time, as well as significant investigative, legal and policy capabilities and resources. But we remain committed to the task. As the Assembly's co-focal point on complementarity, Australia would like to thank the Court and States Parties for their continued engagement on this critical issue. We look forward to facilitating ongoing dialogue on complementarity, as well as continuing our work as co-focal point to support the Court's survivor-centred approach to accountability for sexual and gender-based crimes. We also look forward to the release of the Office of the Prosecutor's paper on complementarity and cooperation, which will provide useful insight into the Office's approach to assessing complementarity and working with states to support national efforts. Madam President, as we reflect on the past year, Australia commends the Court, States Parties and civil society on their continued efforts at reform to strengthen the institution. Australia will continue to work in partnership with you to ensure the Court is best placed to fulfil its important mandate in combating impunity for the most serious international crimes. Now, more than ever, we need to stand by the rules, norms and institutions that prioritise the peaceful settlement of disputes and deter the commission of atrocities that undermine peace and security, human rights and sustainable development. At a time when these foundations of the global order are under great threat, we must continue to support the Court as a critical pillar of the international rule of law. Thank you.
Thank His Excellency for his intervention, and now I call His Excellency Alain Germaud, Head of the Legal Service, Ministry of Foreign and European Affairs of Luxembourg.
Madam President, Excellencies, ladies and gentlemen, Luxembourg aligns itself fully with the statement delivered on behalf of the European Union. As we celebrate the 25th anniversary of the adoption of the Rome Statute and the ICC, Luxembourg reiterates its unfailing support to the Court, as well as its support for promoting the values and principles of the Rome Statute. The creation of the ICC represented a major step forward in the fight against impunity, with a view to ensuring the accountability of the perpetrators of the gravest crimes affecting the international community. The Court has had to deal with many challenges with resilience and perseverance. It has adapted to change and attempts to undermine its role and legitimacy. I wish to pay tribute to the staff of the court for their considerable efforts during this extremely difficult year. Any threats or attacks against the court, its staff, or anyone cooperating with it on the system or its independent operations are unacceptable. The recent attacks against the court are unacceptable. My country will provide its full support to ensure the protection of the court and its staff against external oppression and threats. Madam President, conflicts continue to rage. The war of aggression by Russia against the Ukraine through to the war in the Middle East, in Africa and other continents. Atrocities continue to be committed every day. In this context, we must have an international criminal justice system that is capable of prosecuting the gravest crimes. Current investigations cover almost all regions of the world. We must be firmly united in our commitment to ensuring that the perpetrators of atrocities answer for their acts. All situations deserve equal attention. The role of the court is more essential than ever. This is necessary to provide justice for the victims who must be at the center of our efforts. Luxembourg commends the increase in the activity of the Fund for Victims, and we are proud to be regular contributors to this fund, which plays a key role in the administration of justice and ensuring that thousands of victims receive reparations and critical assistance. Madam President, with a growing number of investigations, the workload of the court is greater than ever. In order for the ICC to continue to deliver, both for us and for its victims, it must be adequately financed. The means available to it must be increased in order to adapt to the workload and to allow it to fulfill its mandate in full impartiality and in full security. It is particularly important to replete the contingency fund in order to address situations that could not be anticipated when the budget was adopted. My country fully subscribes to the promotion of good governance and a healthy working culture that guarantees inclusion, fair geographic distribution, and gender equality. I also hail the establishment of a reasonable diligence process for the election of 6 judges this year in order to ensure that the candidates have all of the qualities provided for in the Rome Statute. We warmly congratulate the judges elected this year. We welcome a verification process for all elections. Madam President, Luxembourg encourages states parties to ratify the amendments to the Rome Statute. This relates to amendments on certain categories of weapons, an amendment on deliberately starving civilians, as well as amendments relating to the crime of aggression, which is the supreme international crime, to use the terms of Nuremberg. You should align the jurisdiction of the ICC on crimes of aggression with those in place for the 3 other crimes, and Luxembourg will be actively involved in this process. I wish to thank Armenia for recently ratifying the statute and thus becoming the 144th state party. The universality of the Rome Statute is now more fundamental than ever. Madam President, Luxembourg gives great importance to justice for children. Together with the court, we must equip ourselves with specific expertise regarding children and encourage an exchange of best practice in order to ensure that children receive special attention throughout judicial proceedings. In this context, I wish to commend the new general policy of the Office of the Prosecutor relating to children and the new general policy in relation to gender-related crimes. I also hail the action of civil society. We must preserve this space that allows civil society organizations to contribute to the fight against impunity and redouble our efforts to protect civil society and human rights defenders from any reprisals. Madam President, I wish to conclude by recalling that the Rome Statute relies on complementarity and cooperation in order to ensure international criminal justice is applied. Member states are bound to cooperate with the court, and I urge all countries to deliver all of their cooperation to the state in order for it to fulfill its mandate with independence and impartiality. It is only through cooperation, multilateralism, and respect for international law that accountability and justice can truly be guaranteed. I wish, finally, to thank the outgoing President, Her Excellency Silvia Fernandez-de Gourmandi, for her commitment throughout her term. I also wish to congratulate the incoming President and wish him every success. You will have the unfailing support of Luxembourg. I thank you.
Je vous remercie.
I thank you.
Invite Ms. Hannah Frost, Deputy Head of Mission at the Embassy of New Zealand to the Kingdom of the Netherlands.
Madam President, New Zealand considers the court to be a central pillar in the international rules-based order and the international criminal justice system. 25 years after it was established by the Rome Statute, we commend the significant progress made in both delivering justice for victims and accountability for perpetrators of some of the most serious crimes of international concern. We note the substantial progress the court has accomplished this year concerning conflicts and alleged crimes across 4 continents. I especially acknowledge the role that the Office of the Prosecutor, the judges, and the Registry of the International Criminal Court in this work, working in partnership with states parties. We would start by acknowledging the prosecutor, the deputy prosecutors, and their teams for the dedicated work and service to the court and its mandate. This includes arrest warrants for President Vladimir Putin and Maria Valabelova for alleged war crimes of unlawful deportation and unlawful transfer of children from Ukraine. The court's activities also includes work in northern Uganda, Darfur, Mali, and the Central African Republic. We also note the open and ongoing investigation on the situation in Palestine. New Zealand recognises the ICC has jurisdiction over alleged war crimes committed since 13 June 2014 in Gaza and the West Bank, including East Jerusalem, as well as with respect to crimes committed by nationals of states parties. As the prosecutor has noted, the investigation includes the attacks that took place on 7 October 2023 and the subsequent escalation of hostilities and violence. Madam President, we welcome the election of 6 new judges this year. We are confident that those elected will continue the court's work in holding to account individuals responsible for the most serious international crimes and will support the overall good functioning of the court. The cooperation, assistance, and support of all states remains essential to the court's operation and fulfilment of its independent and impartial mandate. States parties and others must provide the necessary cooperation and assistance to help end impunity for the perpetrators of the most serious crimes of concern by facilitating their arrest and surrender to the court. We also call on countries who have not yet done so to ratify and accede to the Rome Statute. New Zealand supports a well-run court. We thank the Registrar and his team for their work to ensure all pillars of the court have the support they need to do their work. We remain focused on ensuring the court is sufficiently resourced to enable it to continue undertaking its investigations and prosecutions independently and impartially. We support a regular budget that is reasonable, justified, and fiscally responsible. We thank the Committee of Budget and Finance for its guidance in the lead up to this year's Assembly. Madam President, New Zealand is concerned about the number of direct threats facing the court. It is unacceptable that arrest warrants have been issued for elected officials and personnel of the court. It is also unacceptable for certain actors to compromise the security of the information systems. Notwithstanding these efforts, we trust the court will not be deterred from pursuing its vital mandate. New Zealand acknowledges the important work of the Trust Fund for Victims. We commend the fund for its efforts this year, delivering real and meaningful justice to thousands of victims, their families and communities. We were pleased to provide additional voluntary funding to the Trust Fund this year. We encourage other states parties to consider supporting the Trust Fund through a reasonable regular budget and through voluntary contributions. Separately, New Zealand also takes this opportunity to note our support to continued discussions around serious environmental damage and destruction at a global level. Finally, New Zealand looks forward to becoming a member of the Bureau and to serving all states parties in this capacity for the coming 3 years. Thank you, Madam President.
I thank you for your statement and now invite His Excellency Mr. François Alabrune, Ambassador to the Kingdom of France to the Kingdom of the Netherlands.
Madame la Présidente.
Distinguished President of the Assembly of States Parties, distinguished President of the Court, distinguished Prosecutor, distinguished Registrar, ladies and gentlemen. In addition to the statement made by the European Union, which France supports, as we commemorate the 25th anniversary of the Rome Statute this year, we should like to recall the constant and unwavering support of France for the ICC since its creation. We show this support on a number of fronts. In operational terms, France has continued to provide its full support for all of the investigations and activities carried out by the court. Moreover, it has pursued its commitment, along with Senegal, in co-facilitating cooperation to move forward state mobilization in the area of arrests, the protection of witnesses, court security, and financial investigations. Moreover, France has called for a bolstering of cooperation between the court and the United Nations. In terms of cooperation, France has continued to respond to requests for cooperation from all bodies of the court, as well as requests from the defense. We welcome the entry into force on the 17th of July of the agreement on the enforcement of sentences, which it concluded with the court. It encourages the prosecutor to continue public consultations on these documents that are general in nature, political general documents. This will enable the states and civil society to share their experiences with the office. In terms of human resources, France has made available to the Office of the Prosecutor staff from the Ministries of Justice and the Interior so that it can address an increase in its activities. On the financial front, this year, France has made voluntary contributions amounting to more than 300,000 euros, including a contribution of 150,000 euros for the Victims' Trust Fund. The court is the cornerstone of the global system of international criminal justice. Its role is essential in combating impunity of perpetrators of these most serious crimes and ensuring that justice is served for the victims. With this in mind, France organized a conference on vulnerable victims last May, and the president of the court participated in that conference. Ladies and gentlemen, France continues to call for the universality of the Rome Statute and welcomes the recent ratification by Armenia. More than ever, the court needs our support so that it can carry out its mandate in full independence and impartiality, and that is why any attack against the court and its staff is unacceptable. France condemns the cyber attacks which the court has recently experienced, as well as the criminal prosecutions initiated in Russia against members of its staff. The court must also work on challenges related to how it operates. And that is the purpose behind the review exercise. We welcome the work that has been done in this area by the court in cooperation with states parties. This year, our assembly session has been marked by the renewal of 1/3 of the judges. France is particularly pleased with the election of Nicolas Guillou, and we would like to thank all delegations who voted in favor of this candidate. He will show his humanity, his professionalism as an official of the court, and we acknowledge the diversity of the other judges who've been elected. And we recognize, it's a strong reminder, in fact, that the ICC can only function with a good balance of legal systems, respect for multilingualism, and better geographic and gender representation. France acknowledges the role of civil society, in particular when it comes to the verification procedure. And finally, this is to further bolster the professionalism of court officials. France supports the Ethica project on ethical principles for the international criminal judges. The court is an institution which, in order to prove itself up to the mission we have entrusted to it, must be defended and bolstered in the long term. France reiterates its full support not just for the institution, but its support for all staff. In particular, we thank the President of the Court and the judges who will take on their mandate very soon. And we would like to thank you, Madam President, for the exemplary way in which you are guiding our work, and we wish you every success. Thank you.
Now I invite Ms. Kaija Suvanto, Director General of Legal Service of the Ministry of Foreign Affairs of Finland.
Madam President, Excellencies, ladies and gentlemen, Finland aligns itself with a statement delivered earlier by Spain on behalf of the European Union. This year we celebrate the 25th anniversary of the Rome Statute. As the statute has reached maturity, the Court today is involved in the full scope of activities envisaged in the legal instrument laying the grounds for its activities. The ICC has become a central institution in the rule-based international order. It remains an important avenue to access justice, assistance, and reparation to thousands of victims and survivors around our world. Finland is a long-standing supporter of the ICC Trust Fund for Victims. Restorative justice remains a key feature of the Rome Statute system. The review process and the implementation of approved recommendations provide an opportunity to further strengthen the Rome Statute system and ensure it is fit to face the next quarter of a century. Madam President, nearly 2/3 of all UN member states are also state parties to Rome Statute. Finland warmly welcomes Armenia to this family and hopes other states will follow its example. Universality of the Rome Statutes remains a central goal. Widest accountability gaps remain in situations where atrocity crimes take place, but the ICC lacks jurisdiction. In other situations, the ICC has jurisdiction but lacks access. We see the undeniable benefits of full access in the expeditious manner the work in the situation in Ukraine is progressing. We welcome the recent visit of Prosecutor Khan in Israel and in the occupied Palestinian territories. Regardless of the level of cooperation, it is vital to advance the work in all situations. Finland urges all states, whether state parties or not, to cooperate with the court, to allow access, to share information, to execute arrest warrants. We in this assembly have a legal obligation to follow the rules on cooperation enshrined in the Rome Statute. Finland stands ready to do its part. Madam President, any threats or attacks against the court, its personnel, or those cooperating with it are unacceptable. Finland condemns the criminal proceedings initiated by the authorities of the Russian Federation against the prosecutor, the president, and other judges of the court. The recent unprecedented cyber attack on the court highlights the urgent need to protect the ICC and invest more in its security. Finland has always underscored that the court should have adequate regular budget resources to cover its mandated activities. Civil society and human rights defenders are often the first to alert states and the ICC of serious violations of international law, wherever they take place. This cooperation is not without risk. Finland warmly welcomes the newly adopted guidelines on the protection of those participating in the Assembly. The Assembly must remain in a safe space for all. Madam President, before closing, allow me to express our gratitude to President Fernandez de Gurmandi for her outstanding leadership and to all state parties for their support in the election of Ambassador Päivi Kaukoranta as the next president of the Assembly of State Parties. Ambassador Kaukoranta has a long history of working closely with the ICC, stemming back to the negotiations leading up to the Rome Statute. I am confident that under her leadership and that of the two vice presidents and the Bureau, this Assembly is in good hands. I thank you.
I thank you for your statement. And now I invite His Excellency Mr. Francis Danti Kotia, Ambassador of Ghana to the Kingdom of the Netherlands.
Madam President, Excellencies, distinguished delegates, allow me to convey Ghana's appreciation to Her Excellency Judge Sylvia Fernandez de Gurmandi and the Bureau for the sterling leadership they have provided states parties during her tenure, and in particular throughout the year for the diligent work done in guiding the proceedings of this session. In the same vein, I welcome the election of the Ambassador of Finland as the President of the Assembly of States Parties and congratulate all new office holders of the Bureau. I assure you of the full support of my delegation for a successful conference and of your tenure. My appreciation also goes to the President of the Court, Judge Piotr Hofmanski, as well as the Secretariat for the excellent work done in the management of the affairs of the Court. Madam President, at the onset of the creation of the Court, former Secretary General Kofi Annan of blessed memory said, and I quote, "This course is the course of all humanity," unquote. After more than 25 years of its existence, this assertion by the late Kofi Annan continues to provide us with a clear directional path and undergirding philosophy for the court. It is in this light that Ghana cherishes and remains committed to the principles and ideals of the Rome Statute for addressing atrocity crimes, thereby deterring potential perpetrators of such heinous crimes. We will continue to work assiduously with the court through its organs to ensure continuing realization of the ends of justice and accountability. It is worth noting that since its inception, the International Criminal Court has helped to deliver justice to victims around the world and to deter the grievous atrocity crimes, thereby promoting the norms of international criminal justice. While these are commendable, the court is still faced with challenges as international peace and security continue to be threatened by incidents of armed conflicts around the world with their attendant violations that may amount to crimes under the Rome Statute. As we encounter new challenges, what is required more than ever is for states parties and relevant stakeholders to continue to invest their efforts to enhance the efficiency and effectiveness of the court, to better fulfill its mandate, and ensure greater accountability for atrocity crimes. The commemoration of the 25th anniversary of the adoption of the Rome Statute in New York and Syracuse was auspicious in enhancing the visibility of the court while encouraging greater accession of non-state parties to the statute. To that end, we underscore the importance of universal ratification of the Rome Statute in furtherance of universal jurisdiction of the ICC and call on states not yet party to the Rome Statute to accede to it. We call for continuing sensitization on the principles of the statute and responsibilities of the court for greater understanding by peoples of the world. Madam President, concerning Africa and the ICC, Ghana continues to advocate for dialogue and engagement in addressing the challenges the court is confronted with, particularly the strengthening of relations between the court and African states. To this end, we commend the court and states parties for their collaborative efforts at deepening cooperation and complementarity in favor of justice for the victims of atrocity crimes. We commend the President of the Court, Judge Hofmansky, for establishing channels of effective communication with the African Union Commission for mutually beneficial engagement and constructive collaboration. Ghana has always strongly supported the key pillars and principles underpinning the Rome Statute, namely complementarity, cooperation, independence, impartiality of the court. We affirm the need for effective operationalization of the principle of complementarity in furtherance of the full realization of the objectives of the framers of the Rome Statute at the national level. Consequently, we commend the court's activities and impact in the Central African Republic and President Hofmansky's working visit to Bangui in 2022 to meet with community leaders and victims benefiting from the Trust Fund for Victims. We call for more of such complementarity initiatives of the court and effective partnerships with local authorities in enhancing the capacity of national jurisdictions in dealing with the most serious crimes of concern to the international community. My delegation also commends voluntary contributions to the Trust Fund for victims of crimes of the Rome Statute in furtherance of restorative justice. Ghana welcomes the opening of preliminary investigations into several situations outside the African continent by the court and the establishment of the Office of the Prosecutor Offices abroad. This development and its visible outcomes could help dispel the perception that the court unduly concentrates on Africa, since the notable crimes under the statute remain international crimes, regardless of the geographical region of the commission of such crimes. The court must be seen to have its searchlight everywhere and must be seen to be responsive to atrocity crimes committed anywhere without any equivocation. Madam President, Ghana commends the ongoing review of the ICC and the Rome Statute system, focusing on the clusters of issues of governance, the rules and procedures of the court, as well as investigations and prosecutions. My delegation lauds the group of independent experts for their efforts and submission of their comprehensive report. It is our hope that states parties, focal points, specialized working groups, organs of the court, and all stakeholders would keep up the momentum for the effective implementation of the recommendations to ensure that the review process is successful in enhancing the efficient performance of the court and the Rome Statute system. I acknowledge the support of the International Criminal Court in the activities of the African Center of International Criminal Justice at the Gimpa Law School in Ghana. The center, which was established in May 2017, is dedicated to the promotion of international criminal law and justice in Africa and the world, in particular through research, capacity building, seminars, and advocacy. The center has already proven its worth as it has emerged as a preeminent center on legal scholarship and training in the field of international criminal justice. The visit of President Hofmansky to the center in September 2022 is yet another testament to the continuing invaluable contribution and commitment of the court to the development of the center in Ghana. Madam President, on organizational governance, my delegation wishes to stress the importance of ensuring fairness and equity in the recruitment of staff of the court in as wide geographical and gender balance basis as possible, based on the highest standards of efficiency, competence, integrity. This will no doubt give equal opportunity to competent nationals of all states parties to bring their varied experiences and perspectives to bear at the court to enhance institutional efficiency while ensuring impartiality in the workings of the court. I would like to take this opportunity to congratulate the 6 newly appointed judges to the court and assure them of my delegation's support in their work. In conclusion, Madam President, permit me to express my delegation's appreciation to the government and people of the Royal Kingdom of the Netherlands for their continuous support in hosting the court in The Hague, and our appreciation also goes to the United Nations for hosting the 22nd session of the ASP. I thank you for your kind attention.
I thank His Excellency for his statement, and now I invite Mr. Mateusz Kowalski, Head of International Law Department of the Ministry of Foreign Affairs of Portugal.
Madam President, distinguished delegates, ladies and gentlemen, Portugal aligns itself with the statement delivered on behalf of the European Union by Spain. It is with great honor that today Portugal addresses the Assembly of States Parties to the Rome Statute of the International Criminal Court. Let me begin by thanking you, Madam President, for your commitment to the Rome Statute system along all these years, and particularly for the able manner you led this Assembly. Portugal would also like to convey its appreciation to the outgoing judges for their devoted service to the courts in particularly demanding circumstances. These are times of renewal. Portugal would like to congratulate the President-elect of the Assembly of States Parties for her election. Ambassador Caucuranta, you may count with Portugal's full and active cooperation. Allow me also to congratulate the newly elected judges. We are confident of their positive contribution to the work of the court and to international justice in general. Finally, Portugal would also wish to acknowledge the important role that civil society plays in the Rome Statute system since its beginning. Madam President, 25 years after the adoption of the Rome Statute, the International Criminal Court is a fully established judicial organization whose important role is today widely acknowledged. Of course, there is still room for improvement, which should continue to drive our full commitment. Nevertheless, the court is undoubtedly today a stronger judicial entity with investigations in different regions of the world and a beacon of the fight against impunity, thus contributing to a lasting and sustainable peace. Those responsible for atrocity crimes, regardless of their power and status, learned that they are no longer able to hide behind the shield of impunity. Victims can aspire to justice and reparation. Communities have additional means to seek reconciliation and peace. It is in a way due to this increasing relevance that the court faces today unprecedented attacks and threats directed at it and at its officials by those who seek to disrupt its vital role and undermine the international criminal justice system. Such actions deserve our strongest condemnation. They cannot be tolerated, and they shall not deter us. Portugal stands by the International Criminal Court as a strong and independent judicial institution. We are committed to cooperate during this session in seeking to provide the court with the resources it needs to efficiently and sustainably address the challenges it has before it and to continue to live up to the important responsibilities and expectations that fall upon the Court. Madam President, we celebrate the 25th anniversary of the Rome Statute at a time in its existence when it has never seemed more appropriate to emphasize the importance of the role of the International Criminal Court. As conflicts unfold in different geographies, we are confronted with situations that seriously disturb the common conscience of humanity and the values enshrined in the Rome Statute, which we all collectively share. We reaffirm our support for the consistent implementation of the Court's mandate across the situations and cases under its jurisdiction in the interests of justice and the rights of victims. Accordingly, we count on the prosecutor and its office to investigate all situations under the jurisdiction of the ICC. We trust the Court to bring justice wherever and to whoever required. Madam President, the 25 years of the Rome Statute should also emphasize our responsibility towards building an ever more robust international criminal justice system. Although the Rome Statute provides for 4 core crimes, the exercise by the Court of its jurisdiction over the crime of aggression remains too restricted. The supreme international crime seems in fact to be a crippled limb of the Rome Statute system. Indeed, the investigation and prosecution of the crime of aggression mostly exists as a theoretical possibility. This contributes to discrediting and weakening the Court. The accountability gap in what concerns the crime of aggression must therefore be addressed. Portugal, together with others, is committed to filling this gap, and we call upon all states parties to consider initiating joint work towards amending the Rome Statute in order to put the crime of aggression in the same footing as the other 3 core crimes. The Court needs to be capable of intervening to ensure that also acts of aggression do not go unpunished. Madam President, integrity and universality of the Rome Statute remains, and it will remain, a fundamental priority for Portugal. We thus take this opportunity to congratulate Armenia for having recently ratified the Rome Statute. Madam President, to conclude, we would like to recall that the Court is as stronger as the commitment and cooperation of states parties with the courts. We pledge once more the strong support of Portugal to the International Criminal Court and affirm our commitment to working with you and every delegation towards the successful session of this Assembly of States Parties. I thank you, Madam President.
I thank you for your statement, and now I'll give the floor a Su Excelencia, Señor José Javier de la Gasca López Domínguez, representante permanente de Ecuador a las Naciones Unidas.
Permanent representative of Ecuador to the United Nations, you have the floor. Thank you very much. Madam President, distinguished heads of delegation, excellencies, I would like to begin my statement by expressing our appreciation for the excellent work of the President of the Assembly, Silvia Fernandez de Garamendi, the Vice Presidents, and the members of the Bureau and the Secretariat of the Assembly of States Parties who have worked so hard to ensure the successful holding of this session. My delegation also wishes to congratulate the new President of the Assembly, Päivi Kaukoranta, and the new Vice Presidents and members of the Bureau, as well as the 6 judges recently appointed. Given that this is the first time that I'm intervening in this Assembly, I wish to say that we welcome the election of Osvaldo Salvaguer as Registrar to the Court in February, the first Ecuadorian Latin American to occupy this position, and I wish him every success. The adoption of the Rome Statute in 1998 constituted one of the most notable achievements of multilateral diplomacy. It was made possible thanks to a shared sense of humanity in the face of the suffering that had been caused to the victims. 25 years later, the ICC has become an integral part of the international structure that defends the rule of law, enhances respect for human rights, and in combating impunity. The court has set down valuable precedents and placed victims at the core of its activities. The Kampala amendments have further demonstrated the will of states parties to solidify the scope of the statute, a task that we believe still has room for improvement. As the number of countries supporting the court grows, the objective of universalization of the Rome Statute becomes more necessary. It is encouraging to note that the number of states parties to the statute has doubled since its entry into force. In this regard, Ecuador wishes to highlight the recent accession of Armenia. Ecuador gives particular importance to the principle of complementarity. We therefore call on states parties to intensify their cooperation with the court and to adopt norms that ensure the enforcement of the provisions of the statute in their national systems. In a particularly complex international environment, adequate functioning of the court becomes fundamental. This assembly gives us the opportunity to think about the challenges that it is facing, and we would highlight the following. Firstly, we reiterate that any act of intimidation or an attempt to undermine the mandate of the court deserves to be condemned. We are also concerned by cybernetic attacks against their IT systems. We congratulate the Registrar of the Court for the actions that have been taken in order to mitigate its effects, to avoid this reoccurring and to strengthen those areas that were breached. Secondly, initiatives guided towards shoring up the independence and efficiency deserve to be deepened. We highlight the importance of the review mechanism and the establishment of a continuous due diligence process for the selection of functionaries, an initiative that Ecuador had the honor of co-facilitating, and also highlight the importance of ensuring that the composition of the Bureau reflects the geographical diversity of the states parties. Thirdly, Ecuador is cognizant of the need to ensure predictable financing to the court and to the Office of the Prosecutor to ensure that it can complete its mandate. For this reason, we take note of the work carried out by the Budget and Financing Committee. Our position in this regard has been to seek greater streamlining of available resources with greater efficiency in order to avoid increases in budget and to advocate for the adoption of a budget that guarantees the operations of the court and that takes into account the economic realities of states parties. Fourth, we highlight the importance of bolstering cooperation and coordination between the court and the United Nations. By way of conclusion, Ecuador reiterates its support for the ICC and for the critical role that it plays in terms of holding perpetrators to account for graves that are of concern to humanity and for its contribution to maintaining peace and security. In this lies the spirit that guided its establishment, and it should be preserved. Thank you very much for your intervention.
His Excellency Mr. Christian Venneweser, Permanent Representative of Liechtenstein to the United Nations.
Thank you very much, Madam President. Madam President, I want to thank you, first of all, for your excellent dedicated service to the court over the past 3 years. And I also wish to welcome your successor, Ambassador Cacorante, as the new president of the Assembly. We look forward to working under her leadership. We also warmly welcome Armenia, which has joined the community of states parties, an important step on the long road to universality. The court is looking back at an eventful year which has illustrated, often tragically, the growing importance of its work and the need for our political and financial support. This Assembly must produce positive results in this respect. Support from us is crucially important at a time when the court finds itself under direct attack. Massive cyber attacks, which were highly disruptive and costly both financially as well as in terms of efficiency of the court's work. More dramatically still, senior officials of the court have been subject to unprecedented retaliatory measures from the Russian Federation simply for doing the job that we have asked them to do. This must be a matter of urgent attention for us and, in fact, also for states who have not yet joined the Rome Statute as a frontal assault on the principle of judicial independence, a key principle for any judicial institution, internationally or domestically. Our joint and unequivocal support for the court in face of such attacks is key. Equally important is that we equip the ICC with the resources it requires to carry out its tasks. Last year, our general debate generated many statements of support and calls for action with respect to the situation in Ukraine. This year, the world has been shaken by the terrorist attacks on the civilian population in Israel and the massive crisis of respect for international humanitarian law that followed and is still ongoing. This does not mean that the need of the court's work in Ukraine, or indeed in Myanmar, in Libya, in Darfur, have decreased. Quite the opposite. Our obligation at this session is to equip the court, and in particular the Office of the Prosecutor, with the financial resources it requires to do the work that we expect it to do. Our statements of support for the court are only credible if backed up by concrete action, most importantly with respect to the court's regular budget. The only way to ensure both effectiveness and prosecutorial as well as judicial independence. Madam President, 25 years after the adoption of the Rome Statute, it is safe to say that the treaty and the vision contained in it continue to be a beacon of hope for victims of serious crimes around the globe, and the basis for effective prosecutions before the ICC itself, or ideally in national judiciaries. There is, however, no room for complacency. For the first time, the General Assembly of the United Nations did not welcome the annual report of the ICC by consensus, but rather voted on it. It was a small number of states that followed the Russian Federation in its opposition, but it is a reason for concern that not all state parties voted in support of the relevant decision. We need a respectful and open dialogue in moving forward, and to take this as an opportunity to forge a stronger political consensus, first among ourselves, and then also within the wider UN membership. An important aspect of this is to implement the truly global nature of the court with respect to the court's own activities, but also on our side, the state party side. Madam President, the quality of the Rome Statute has stood the test of time, but we must also be willing to make improvements to it where they are urgently needed. The most manifest aspect in this regard is the insufficient jurisdictional regime the court has over the crime of aggression, one of the 4 core crimes under its jurisdiction. When we adopted the Kampala amendments, which I had the honor to preside over, we addressed 2 aspects of our big task in a manner which was solid and sustainable. First, we agreed on a strong and consensual definition that is both deep and narrow, and today reflects customary international law, the most successful amendment to the Rome Statute to date. Second, we gave the court the possibility to exercise its jurisdiction also in the absence of a determination of the United Nations Security Council that an act of aggression has occurred, thus safeguarding the court's judicial independence. In the area of jurisdiction, however, we were forced to agree on a regime that is so limited that it does not give potential victim states the protection that they are looking for, and thus also serves as an obstacle to universality. The aggression against Ukraine is the most extreme and blatant illustration of a more general, worrying global trend for states to resort to the use of force in manifest violation of the UN Charter. The agreement in Kampala provides for a mandatory review of the package adopted in light of the experience gathered in the time since the activation of the court's jurisdiction. The conclusion today, and we've heard it from others in this debate, is an obvious one. We need to bring the ICC's jurisdiction over the crime of aggression in line with the other core crimes in the Rome Statute. It is clearly overdue to treat the supreme crime under international law not as a second category issue, but as what it is, an assault on the peace and security architecture established in the UN Charter, a massive violation of the rights of countless of individuals, and often the origin of other horrendous Rome Statute crimes. I thank you very much.
I thank you for your statement. And now I invite Mr. Slavomir Majsik, Director of the Legal and Treaty Department of the Ministry of Foreign Affairs of Poland.
Madam President, Excellencies, distinguished delegates. This year's Assembly began with the election of the 6 new judges, to whom I extend sincere congratulations. I would also like to thank the judges whose term of office is now ending, especially President Piotr Hofmański, who skillfully and resolutely led the court through a period of exceptional challenges and turbulence. I also wish to say a fond farewell to Mr. Renan Vileisis, who from the very outset of this institution has devotedly helped shape its destiny. Please accept our expressions of deepest gratitude. I would like to extend our sincere thanks to the outgoing President of the Assembly of State Parties, Ms. Silvia Fernandez de Gurmendi. Speaking for Poland as one of the newly elected members of the Bureau and Vice Presidents of the Assembly, I assure you that we will work assiduously for the ICC through our term of office. Ladies and gentlemen, Poland aligns itself with the European Union statement made on behalf of its member states and would like to add some remarks in its national capacity. Just a month has passed since we last discussed ICC issues here at the UN on the publication of the Court's annual report. What daunting the new challenges that month has brought, both for ICC and for the international community at large. The opening of a new chapter in the Middle East conflict has already taken an enormous and ever-growing daily toll, and the role of and the responsibility of the court towards these innocent victims cannot be overstated. It is no exaggeration to say that the international community looks on its anxiety and hope that the ICC will prove equal to the tasks ahead. Madam President, the proximity of the war across our eastern border makes it impossible to forget that the Russian forces have been committed international crimes in Ukraine for almost 2 years, which proves that the world needs impartial international criminal justice system more than ever. We should do everything in our power to deliver one. With this imperative in mind, Poland supports the proposal to equate the crime of aggression with other international crimes and to allow the ICC to exercise its jurisdiction in this respect without the special restrictions that currently apply. Distinguished delegates, state parties have justifiably high expectations for the court, but for their part must ensure appropriate conditions for it to operate. For a start, this means that the ICC remains free from outside pressure, threats and attacks. Poland considers any such actions against the court, its elected official or its staff to be unacceptable and unreasonable, condemns them. Secondly, the necessary funds must be available for the ICC to operate effectively, and I trust that in the coming days we will negotiate the best possible budget for the next year. Finally, it is essential that states work together with the court, and Poland will always do its best to ensure such cooperation. Our issue crucial to the operation of the whole international justice system, which is beyond the direct influence of state parties, is the universalization of the Rome Statute. Poland is therefore gratified by Armenia's accession to the statute and appeals to all states not yet party to it to consider joining. Only by acting together can we ensure a strict and effective system of international justice. I thank you.
I thank you very much. I would like to thank all the distinguished speakers today for their statements and the support pledged to the court in the fulfillment of its mandates. Tomorrow, we will start with His Excellency Mr. Rati Bregadze, Minister of Justice of Georgia. And then the Minister of Justice of Georgia will be followed by the Minister of Foreign Affairs of Guatemala, Mr. Mario Bucaro Flores. So the meeting is adjourned.